just to follow up on that, am I correct to say then that what you're saying is that this section of the bill potentially could lead to 10 to 15 years of litigation, uncertainty, simply to get us back to the point we're at levels of certainty that we have now? That's a possibility.
Yeah, well, it's a probability.
Probability.
The courts, in fairness to them, are not forcing people to advance cases while there's cost risks, and they're allowing them to have the issue determined as a preliminary matter, and to have that finally determined before the case goes on. So if there is uncertainty over the costs at the start, people will just make applications either to invalidate the legislation or to find some other remedy. And we found with the Heather Hill case, there was a parallel case called Enniskerry Alliance, which almost ended up in a preliminary reference to the ECJ, because there's another parallel cost regime called the Environmental Miscellaneous Provisions Act 2011. So, like, I think the whatever about the scheme or whatever, there has to be, basically you need to have reasonable predictability of costs. Like, the issue isn't environmental litigation. The issue in Ireland is our costs are just really, really high. And that goes across the board, all types of legal proceedings. So this isn't specific to environmental litigation. So what's specific to environmental litigation is that the costs can't be prohibitively expensive and there has to be fair and equitable procedures. That's what's different. So, what we have is a system that kind of works and has achieved kind of stability. And the fear, like, when we don't know what's going to replace it, it's very hard to imagine something different when we actually have something that's stable and people can use. And I think also to remember, costs are so high in Ireland that developers can't afford to take judicial reviews. So if you look at all the developer litigation, they're also relying on cost protection. So the only people who can really afford to take these judicial reviews are very, very big developers, very wealthy people, and public bodies or the state sometimes. So it benefits everybody actually to have good cost rules that don't prohibit litigation. But the thing is, like, the thing to avoid is any kind of uncertainty or any kind of, hard parameters that give rise to somebody needing to make an application to have the issue resolved. And what we have now today, it's almost automatic. All judicial reviews under the Planning Act benefit from cost protection, regardless of their substance. And there's a kind of a safeguard that if it's a frivolous or vexatious, or if there's contempt of court or some other bad behaviour, there is a potential for some kind of a cost order. But that rarely, if ever, happens, because people generally are quite well represented, so they can afford to hire lawyers, and the cases are quite good. And as Oireachtas said, there's kind of a selection bias, so that we generally take cases that we can win. So obviously that's how we get paid. And there's also a kind of a disciplining bias in cost recovery from the public body. So I think the committee is well aware of the amount of legal costs that the board incurred. So that shows up on their annual report. They have to account for why they spent a lot of money losing cases. So that actually has another kind of positive benefit as well in the board, conceding cases early to avoid cost. And actually to make good decisions so that they don't have to show a huge legal spend when they lose cases.
Okay, thanks for that. And then just a question for